So friends, did you see Donald Trump's social media post? A directive to Pam Bondi demanding that his enemies be prosecuted. With the message being, evidence be damned, prosecute these people. Here is how that post reads in part. Pam, I have reviewed over 30 statements and posts saying that, essentially, quote, same old story as last time, all talk, no action, nothing is being done. What about Comey, Adam, Shifty, Schiff, Leticia? They're all guilty as hell, but nothing is going to be done. We can't delay any longer. It's killing our reputation and credibility. They impeached me twice and indicted me 5 times over nothing. Justice must be served now. President DJT. Friends, if Trump can find a flunky U.S. attorney, a lapdog U.S. attorney, a sycophant U.S. attorney who is unethical enough to try to prosecute Trump's enemies, those enemies are going to have one hell of a vindictive prosecution defense. In this video, I discuss with constitutional law professor and former federal prosecutor Kim Wehle the legal defenses of vindictive prosecution and selective prosecution. Because justice matters.
Welcome, everybody. I'm glad to see you all jumping on in the middle of the day rather than our usual 8:30 hour. We had a great hour-long Q&A last night where folks on Substack submitted their questions, and I tried as best I could to answer every one. That's a recurring segment on Sunday nights, so anybody jumping on who hasn't been part of that, you're invited to join us every Sunday night at 8:30 p.m. Eastern Time for our community meeting Q&A session. So I'm going to jump right in as people are signing on. So we're back with our friend Kim Wehle, constitutional law expert, professor for 17 years at the Baltimore University School of Law, former federal prosecutor, and somebody who puts so much content out there about the rule of law and how it is operating or failing to operate today that every time I read something Kim posts, I'm like, okay, I got to bother Kim again. And she's part of our team Justice, and she comes to our annual Justice gatherings and gets the crowd whipped up and explains what's going on. So, Kim, thank you for jumping on again today with our Team Justice crew.
Always great to be with you, Glenn. You know, education is the people ask all the time, what can I do? Educate yourself and share what you learn with one person. We have to understand the foundation and the basics of all this if we're going to fix it.
And Kim, when I saw that you had posted something, I believe on Substack, I get all the notifications anytime you post anything about selective prosecution, vindictive prosecution, and obviously this is something that we need to talk about in the wake of Donald Trump's insane social media post, which is directed to Pam Bondi. It feels to me when I read it like he meant it to be a direct message, a private DM to Pam Bondi,
where he says things like, we can't delay these prosecutions any longer. It's killing our reputation and credibility.
That's not the way Donald Trump tends to speak publicly. And he directs this right to Pam Bondi when he is railing about how his enemies have not been prosecuted. What about Comey? What about Adam Schiff? What about Leticia James? They're all guilty of something. They need to be prosecuted. And so I think, Kim, when we saw that, instantly we think about how selective prosecution and vindictive prosecution are defenses when somebody is indicted, is being prosecuted for something that violates the due process rights of that person to not be selectively or vindictively prosecuted. And I have to say, I went back and reread your Politico article from February And the title of that article was "A Warning to Trump Targets: The Law Isn't on Your Side." That sounds ominous. I read the whole thing. I reread it. I read it the first time. And you end by saying this, which was sadly prophetic. You say, prior to Trump's inauguration, a presumption of prosecutorial regularity probably made sense. But now that Trump is the first person in the history of the United States to win the presidency on the promise of criminal vengeance, the law seems ill prepared for what's to come. So can you talk to our viewers a little bit about what the presumption of regularity is and why it has always kind of made sense to criminal practitioners like you and I, why it may no longer make sense, and then we'll talk about what selective and vindictive prosecution is really all about and why it might not offer the protections that we think it should offer people who, like Leticia James and Adam Schiff, who Trump is vindictively going after in the layman's sense of that word.
Yeah. So as you mentioned, I've been teaching law for a really long time. And one of the biggest challenges, or which is I put a lot of focus in, is how do you translate this to regular language that people understand? And I know you mentioned my Substack of the Little Law School. I break all of this down. Um, you know, I think it surprises people that the job of a prosecutor is not to figure out who's the bad guy and then find the crime. The job is actually to look at the evidence and see if there's enough to prove it beyond a reasonable doubt, which is a very, very high standard. And if you don't have the evidence, you move on. And this presumption of regularity, that's a legal term. It's essentially the law based on, the independence of the Justice Department, the diligence, the professionalism, the high ethics. I mean, it's a very prestigious position to get a job as a DOJ lawyer in the legal profession. I mean, these folks could go to the fanciest law firms. They want to do the public good, and they go to DOJ. And so the defendants who say, "Oh, this case brought against me was vindictive," or "You went after me politically," the courts basically say, "No, we're going to assume prosecutors are following the law and following the facts, and they're not political, that they're just doing the job of justice. And we're going to make it really, really hard for you to get rid of cases by attacking the prosecutor as biased." That's how the law is developed. And you can speak better to this than I do, having managed probably dozens, if not hundreds, of prosecutors in your career. That's, I think, that's a deference that prosecutors historically have deserved. And that's because they do the work of the people, and they do it with integrity and ethics. Donald Trump threatened over 100 times that he would go after his political enemies. As I tell my students, the difference between somebody in government, a police officer, and a regular person is that if I put somebody in the back of my car in handcuffs, that's a kidnapping. If a police officer does it, they get deference that there's some probable cause or reasonable suspicion of a crime. If it's me that's in the back of the squad car, I got to get a lawyer and disprove it. The government has powers we don't have, which is the reason they should be held to higher standards, not lesser standards. So if you get a president and now an attorney general and FBI director who are loyal to this president, that are willing to use the powers of government to go after political enemies, the law doesn't just come in and stop them. It's really about integrity and ethics. And so if they're not going to adhere to that, then the question is, if they bring prosecutions that are not based on the kinds of ethical standards and evidence that you followed, Glenn, for 30 years, and your prosecutors did, what does the law say? The law says that you have to basically reach a very high level of demonstrating that there was no facts there. And if you're really lucky, you have evidence, kind of a smoking gun evidence, that they were out to get you, that they really were interested in ignoring the law and just using that brute force of law enforcement that they get when they get the job of a prosecutor or an FBI agent or a police officer, or here a president. So it's a very high standard. And one other point, you mentioned due process. The reason it has due process implications, and I talked to my first years about this in a different context today. Due process means that before the government can take your life, execute you, take your liberty, put you in prison, or arrest you, or take your property, basically fine you, you get notice and a fair opportunity to be heard before a court. So that's essentially saying the government in arrest, putting you through the paces of a bogus criminal investigation is taking your life, liberty, and property in a lesser way. But essentially, that's the level. That's what you kind of have to show for a vindictive prosecution. Again, it's very high because the courts have just assumed up until January 20th of 2025 that prosecutors do the right thing for the most part.
And the presumption of regularity, as you explained it, and I thank you for doing that. It essentially makes sense because our experience has been that prosecutors, federal, DOJ attorneys who go in and are sworn to do the work of the American people should enjoy a presumption that what they're doing is not based on personal animosity toward the person they're prosecuting. It shouldn't be based on some kind of selective prosecution where you're going after people because of their skin color, because of their ethnicity, their national origin, or their immigration status. It's that you basically get the benefit of the doubt that you're doing what you're doing for the right reasons, or at least reasons that aren't prohibited by the law, by the Constitution. I think the regularity for my entire career, 30 years as a federal prosecutor, made perfect sense because, as you say, all of the people I supervised, and it was hundreds over the years as a federal prosecutor, we were performing our jobs honorably, and we weren't going after people for personal or political reasons. So
Well,
it
also,
makes
if I could add, Glenn, if it weren't so hard to raise a selective prosecution defense, wouldn't every defendant throw that in there? Probably, because they don't want to go to jail, right? So that defense has the danger of sort of swallowing up the prosecution, just like we see on social media, everybody being attacked as biased. If selective prosecution weren't difficult, it could grind to a halt the process of prosecuting, because every good defense lawyer, if it was easy to raise it and get rid of cases, would raise it.
Right. So it makes sense. Otherwise, the system sort of breaks down and bogs down if you can make these personal attacks on every prosecutor in every case. So I think we're in agreement. The presumption of regularity has always made sense, except now, right? When you have a president who has seized control virtually of the day-to-day prosecutorial decisions and operations of the Department of Justice, when you have Pam Bondi, who I'm sorry is not an honest broker of the law. You have Todd Blanche, former criminal defense attorney of Donald Trump, doing things that no responsible prosecutor would do with respect to the way he was dealing with Ghislaine Maxwell and in so many other matters. I'm writing a piece for Substack right now that today we really ought to have a presumption of irregularity because they're not operating in a regular, fair, honest way. And I found the line in Trump's post. He said, "We can't delay any longer. It's killing our reputation and credibility." And he's saying, "You got to just start charging my enemies." And he names a handful of those enemies in his post. So that brings us to selective prosecution and vindictive prosecution. They're two different defenses. They're kind of kissing cousins to one another. There's a lot of similarities. But in layman's terms, can you tell our friends what is a selective prosecution that might give rise to a challenge by a defendant, and what is a vindictive prosecution?
So, yeah, selective prosecution is that you're picking and choosing your defendant based on characteristics that are not legally justifiable or they're constitutionally protected. So you're only pulling over the cars on the highway that are driven by people of color, for example. A vindictive prosecution is more, political, targeting a political enemy, both of which are problematic, of course. And then I break down in the column, there's also two sort of buckets of how this is dealt with. One is as a defense to an indictment. So make the case go away against me. You're already embroiled in the criminal justice system. And if the evidence is weak, your life could be ruined already, right? Regardless of whether there's a jury verdict against you. And so the argument is, listen, throw the indictment out because I'm being persecuted, selectively prosecuted or vindictively prosecuted. Then there'd be a lawsuit potentially afterwards where you'd sue for violations essentially of your constitutional rights and want money damages and reimburse me for my attorney's fees and all my pain and suffering. That's also a very high hurdle. And generally, the case is you have to have successfully gotten rid of your criminal lawsuit to then be able to follow up with the civil lawsuit. And just to also be clear, Glenn, as I say in the column, there's not a lot of cases on this. We have very thin case law. We don't have a lot to go by because this doesn't happen that often, I would guess, is one of the reasons. So Donald Trump, he's kind of good at this, and I put that in air quotes. He goes for these gray areas and exploits parts of the law that have not been developed because we never needed to.
Mm-hmm.
Because up until now, presidents, prosecutors, attorneys general have gone by the book, or if they haven't, they've done it in secret. And I'm wondering, if I could turn the mic a bit on, to a question to you in this moment, if you can kind of draw a distinction between what we're talking about and I think Todd Blanche coming out, and I know Caroline Leavitt saying that, listen, the investigation of Tom Homan for what looks like taking a $50,000 bribe in a takeout brown paper bag, they're saying, listen, that wasn't something that legitimately should have continued in the grand jury. That was canceled in the early stages of the grand jury. How, Glenn, is that something that there is something there that would justify moving forward as a matter of traditional prosecutorial discretion that is being called by this administration a vindictive or somehow political prosecution or investigation by the Biden administration? I think that identifies a really good counterpoint to what we're trying to talk about, maybe.
Right. We have allegedly, engaged in mortgage fraud, right? But the evidence seems to suggest, at least what's been publicly reported, that Leticia James probably didn't engage in mortgage fraud. There was apparently a document which was described as a power of attorney, which had a box checked, maybe in a pre-populated way, maybe not. We don't really know. We've heard that that said she was going to use this home she was seeking to purchase as a primary residence. But all of the other paperwork that she filled out that was actually used to obtain the loan said no, she wasn't using it for or alleging she was going to use it for a primary residence. And I think that's why even I believe Todd Blanche and company have suggested that there's no case there, but Donald Trump doesn't care. That I think is a marquee example of vindictive prosecution and maybe also selective prosecution if there are lots of people, as we've seen some reporting suggesting people in the Trump administration may have engaged in some mortgage fraud, but none of them are going to be investigated or potentially prosecuted for it. The Homan thing, just spikes my blood pressure because when you have somebody accepting, according to the reporting, $50,000 in cash in a paper bag with a promise that if Trump regains power, I will steer business or government contracts your way. And people may say, well, the crime of bribery wasn't consummated, quid pro quo, this for that. We got the this, here's the 50 grand, but we don't have the that. Why? Well, it looks like in part because the investigation got shut down by the Trump administration. So he didn't even have the opportunity to follow through by directing government contracts to these undercover FBI agents who are posing as businessmen. But I also have to believe that it sounds like you have an attempted bribery charge potentially, because an attempt to commit a crime, if you do more than just some very early preliminary planning and you don't take any overt steps toward the commission of it, he did. He was halfway there, taking 50 grand, the payment. That could be attempted bribery. So, yeah, the Holman thing reeks of kind of the opposite of vindictive and selective prosecution. It's doing unwarranted favors by killing criminal investigations for your political cronies. But let me talk a little bit about selective prosecution and vindictive prosecution, and put a little bit of meat on the bones of the selective prosecution, only because I teach this particular case to my George Washington criminal justice students year after year. I'm on hiatus now, but I think one of the leading cases on selective prosecution, this will give people an concrete idea of what it might look like, was during the Vietnam era, the draft, the selective service. It's a case called Wait versus United States, where, people were not registering for the draft because they were protesters, or they were scared, or they just didn't want to be any part of the Vietnam War. And it was a crime to fail to register for the draft. There were 670,000 people who failed to register for the draft, committed that crime, right? The federal government prosecuted how many of the 674,000? 13 people. And these people screamed, these defendants screamed bloody murder. They talk about an obvious selective prosecution. 13 of us when 670,000 committed the crime. And the Supreme Court said, well, if you're going to be successful in a selective prosecution defense, you have to prove that the government was discriminating in both its effect and its purpose. So, yeah, they discriminated potentially in their effect, 13 out of 670,000. But the purpose they articulated was, well, these 13 were really vocal about their refusal to register. They were encouraging others to refuse to register and commit those crimes. And we have to make an example of them to deter this kind of conduct. Supreme Court said, good to go. Not a selective prosecution. Vindictive prosecution, which I say is closely related, is, in part, okay, there's personal animus driving a prosecutor to want to charge somebody. I've used the example, you know what? I lent my lawnmower to my neighbor, and dude returned it all banged up and it doesn't work anymore. I'm a prosecutor. He's not. I'm going to prosecute him for something. I'm going to find something to charge him with. Now, that's a very simple example. Usually what you have to do is show that you're being vindictively prosecuted because you exercise some right that you have. Like the prosecutor wants you to waive your right to a jury trial and be tried by a judge because it's a lot easier for prosecutors to do bench or judge trials. And the defendant says, no, I want to exercise my right to a jury trial. And the prosecutor says, good, then I'm going to indict you on a whole bunch of other stuff. I'm going to put a bunch of other charges on your head. That's another form of vindictive prosecution. But as you say in your Politico piece, the hurdles that defendants have to clear to successfully make out a selective or a vindictive prosecution are extremely high. And kind of how do you see the Tish Jameses and the Adam Schiffs and the others that he's expressly saying, I just want these folk prosecuted? What do you see their odds are of lodging a successful defense of either selective or vindictive prosecution?
Well, the first point is, as you indicate, I mean, the standard seems to be, and I'm paraphrasing, that so long as the government has some evidence, it's really hard to overcome the evidence by showing that there was selective or vindictive prosecution. So, you mentioned Leticia James, and this is the mortgage applications. The government's going to argue, listen, there's enough there to move forward. I think the Supreme Court's decision last summer in Trump versus U.S., where they, really underscored immunity for the president, and if the directive is coming from the president, and we don't know, but it looks like there could be. I think that with respect to Trump himself, he's going to be able to say, listen, I'm completely immune. Beyond that, there is case law in the civil context, not for the defense in the criminal context, but that basically says, because there is immunity from suing prosecutors in general, that you have a stronger case if you can say that the prosecutor was directed by some higher up or someone else in the office to bring this case. And in that regard, I think these people like Adam Schiff are going to have pretty good evidence, I would say unprecedented evidence, given the public statements. I said over 100 even before Donald Trump took office. We have this Truth Social post ostensibly to the Attorney General, kind of almost it would be smoking gun evidence in a way that there is animus. And in the weighing between selective and vindictive, the vindictive is probably even harder to show, because for selective you can look at the numbers, right? You can look at, like, listen, all these people that weren't prosecuted, I was prosecuted, and look at how I'm situated in a unique way. I think the vindictive, the showing the animus, is harder, and they're going to have some good evidence of that. But like all these Trump cases, I think when they get to the Supreme Court is likely to be very deferential to Donald Trump.
And that's the problem. So let's end on a positive note. And I hope this isn't Pollyanna, but merely positive. So there is nothing in the Constitution about selective prosecution or vindictive prosecution. And there's nothing in federal statutes, I don't believe, that address these legal defenses. What this is, it's a product of courts interpreting what somebody's Fifth Amendment due process rights mean. And they have said it means that you shouldn't be the victim of a selective or a vindictive prosecution, even though they made the bar really high to be successful. What I guess I'm hopeful about, at least in the trial courts and maybe the circuit courts of appeal before we get to the Supreme Court, is they will look at a president who is running through U.S. attorneys that he appointed because they wouldn't do his dirty bidding and bring cases that were not supported by the evidence. Eric Siebert, the U.S. attorney in the Eastern District of Virginia, just resigned. He was on the eve of being fired because he would not do Donald Trump's, it appears, dirty bidding and bring a case against Leticia James that wasn't supported by the evidence. So he's got some other U.S. attorney he's trying to put in there, hoping maybe that person will act in an ethics-free way and do what Donald Trump is demanding. These are such unique and horrific facts that have never been litigated before. A president vindictively, in the real sense, directing prosecutions of his enemies, that I'm hoping that the courts will, again, interpret that as an obvious due process violation, much more egregious than the Vietnam era selective prosecution case, much more egregious than other vindictive prosecution cases that may have been taken up by courts previously. That is my hope. I don't think it's Pollyanna, because the facts are so horrific and so clearly, at least in a layman's sense, show that he is vindictively and selectively pushing these prosecutions on his enemies.
Yeah, I agree with you. It'll depend in part on where they're able to bring some of these cases. There's some judges, for example, we know in Florida, that are more likely to go along with Donald Trump's predilections than other judges. But I would say on balance, and I think the majority of federal judges across the country, some at great risk to themselves, are upholding the rule of law and in some very strong language. And unfortunately, they're not getting their back, covered by the Supreme Court. But not every case can go to the Supreme Court. We're going to see some new law made here. And I would assume some of these folks, particularly the high profile people, will have some of the best lawyers in the country defending them.
Yeah, I do suspect we will see some new law made here. And whether it survives the Supreme Court or not, we'll have to see. But Kim, as always, thank you for jumping on. Can I urge everybody who is not already subscribed to Kim's Substack? It's Kim Wehle, .substack.com, right? Wehle is
right.
Wehle, the little law school. Please subscribe, because this is information that we all need, and you're not going to get this on mainstream media. I'll tell you that.
100%.
Yeah. So thank you, Kim. I will be bothering you as soon as you post something else that I read, and we'll need to jump on with you again. So thank you as always.
Yeah. Well, I appreciate your friendship and your fighting spirit, Glenn. You're an inspiration to everybody. Bye.
Thanks, Kim.
Bye, folks.
Bye.